glad to be with you here, and I'm going to be taking you in criminal law as one of the questions of criminal of law as a law student, and I'm really happy to be with you here. Hope you're going to enjoy everything. It's not going to be hard, but you're going to learn something. Since it's the first session of our class, get ready, enjoy. I'm not boring. First of all, I'm going to discuss for you criminal. What according to the Black's Laws Dictionary, criminal is brought out as an involvement in an act which is easily be offended. You can easily be secured and you can even be taken away from that burden of that offense. So there's so many defenses, and I brought you a few of the defenses so that you can easily get know it. You can get know them and can easily understand them. The first defense that we have is self-defense. Self-defense is provided in the Penal Code Act, Section 15, right? And self-defense is when someone has committed a crime, and that person accepts that yes, I carried out this crime, but it was a self-defense. Do you know what I mean when I'm talking about self-defense? Let's take an example. You are in your own house and somebody came, tried to take away your stuff and kill your life, take away your life, and in the way of defending yourself, you decided to get a knife, and then maybe you pierced him somewhere, and then he accidentally died, and now you are accused of murder. So when you raise such a defense, you can easily be heard. Your case can be easily heard. You either be given your offense may be reduced to manslaughter, or maybe that when the judge decides, he can easily give you an acquittal according to the proof that has been brought on table by your counsel. Another defense, we have accident. Accident is provided in Section 8 of the Penal Code Act, right? Accident, as we all know what an accident is. An accident is something that happens suddenly. You didn't have measure of doing that thing. It happened without your own will. You never wanted that particular thing to happen, but because things just happened and then it happened, so you find yourself carrying out a crime. You're charged of an offense, but you didn't do it willingly. It just came out. Let's take an example. I want to bring this thing in our video so that you can easily understand it, my dears. So, accident in our normal life. Let's say you've been driving your car, then you just then knocked a person. The person died. So you're now charged of murder. Then you can easily raise this defense, and maybe if you raise it, they can easily give you an acquittal or be charged. You get. So accident, you never be done, then you fail to raise it, because you can easily be defended. You can easily be your charges can easily be taken away from you. So guys, don't be tied by the unawareness of accident. Accident is a very good defense. You can raise it. So be careful, and always be concerned with that, right? Another defense of ours is claim of right. Claim of right. Claim of right is provided in Section 7 of the Penal Code Act. Claim of right, here we mean you've been accused that you stole something, when indeed you didn't steal it, but somebody failed to pay your some money. You owed someone money, but that person failed to pay you back. So you're taking this. Let's say you're taking a bicycle, but you're not taking it in bad terms. You're taking it in good terms. And if that person happens to pay you back, then you automatically take that particular thing, that bicycle, that house, that motorcycle, that bag to him. So if you raise that claim of right, then the other issue, the other offense of theft, you can easily be saved from it, and then your case can easily be heard. So guys, you should also know about claim of right. It's a good defense in particular cases. Normally in cases of theft, you can easily raise it and get saved. Are we together, guys? Another difference, we have killing on provocation. Killing on provocation is provided in section 192 of the Penal Code Act. Today I've tried to bring for you the Penal Code. I want to be specific. If it's Penal Code, I want to show you what Penal Code talks about these differences. Then next time I'll make sure that I bring to you what other sources of law talk about different differences. So today we are dealing with the Penal Code, and this Penal Code talks about killing on provocation in section 192 of the Penal Code Act. Killing on provocation is a defense that is raised. Let's take a case like you killed somebody, but you didn't intend to kill that person on the actual grounds. You were just forced. Let's say you've been working, somebody has been working for a certain big man, and that man doesn't want to kill somebody directly, so he's using this person indirectly, and above all, he maybe tells that person, if you don't kill him, I'll maybe kill your family, I'll take away your mother, I'll take away your whatsoever you can. So that person can easily raise this defense of killing on provocation. Then, and the other issue, the other crime, or the other big defense of murder can easily be reduced according to the proof that is brought on the ground. So this killing on provocation is a very good defense to people that are innocent. You know the way this, for people are always innocent and they end up in jails, end up getting huge punishments of which they never deserve to get. So somebody can easily raise this defense, and the case can be easily heard. So guys, endeavor to note this defense, because it's really good and it's really vital, so that somebody can easily get justice. All we need in this world is justice. Another thing, I'll introduce you mistake of fact. Mistake of fact is another defense. This can be raised. It's provided in section 9 of the Penal Code Act. Mistake of fact can be raised in defenses whereby somebody you killed, actually most especially in murder cases, you killed somebody but you never knew that this was really the actual thing. Let's say you've been moving and you are, let's say, in your garden, and you happen to hear, maybe you usually had some disturbances. So because you're used to that, by the time you go there, you find some, like, you hear some noise, so you're suspecting that these are monkeys, these are birds. So you want to secure your millet so that you can harvest something that is huge. But when you're trying to scare away those birds, those monkeys, then you accidentally, let's say you had a gun, this gun, or you had this how they call it, my dear, this
guns, sniper rifles.
Yeah, those things, remember those that they used to use, arrows. You know, guys, we are interacting because this is a friendly session. This is a friendly lecture, so we should all get attentive. I know you're getting what I'm saying. So these arrows they used to, you know, to spear these birds. When you want a bird, you spear it. So you just speared out, and then you didn't know that you're hitting a person. So accidentally you hit a person with that spear or that arrow, and then that person opens up a case in a case of charging you. If that person had got an injury, then they open a case onto you. So because you're innocent about that crime, or even though you carried it, but you're innocent, you didn't intend to do that thing. You didn't intend to injure that person. You didn't intend to kill that person. Let's take a case. The person died. So you can raise this defense of mistake of fact that you didn't know that this was a person. You thought they were animals, they were monkeys. You were trying to scare away those monkeys, those animals or birds. So your case can easily be heard. So guys, note that defense is really good and vital. Another defense of ours that I brought you is a defense of alibi. Alibi is another defense. Alibi is a defense that is raised. They accused you of a certain offense, but in actual sense, for you saying you weren't in that place, you were not in that place when that offense was being carried out. They opened up a case that you killed somebody. They opened up a case you carried out theft somewhere. They opened up a case that you involved in those unlawful acts. But for you believe and you're innocent, you believe that you are not in that area while that offense was being carried out. So you can easily raise this defense of alibi. And remember, this defense of alibi is always raised earlier. If you know that you have that defense, you are not in that place. So you can easily raise it earlier in courts of law so that the prosecutor can easily make research about it in time and make assure the court that you're either good about it or you're not guilty. So guys, don't be misled, don't be kept in that area of ignorance, failing to know laws when you still have this defense of alibi. You should know it. We need justice. I think superior order is provided in section 14. It's some kind of related to our fourth defense, killing on provocation. Superior order is when somebody carried out an offense, but he got orders from another person. So that person cannot be charged of that offense when that person was not willing, was not intending to do that particular offense. So this defense of superior order can easily be raised so that the criminal charges can point to the other person, can be shifted to the other person that official or that spearheaded this act or this crime. So guys, it's good you know that defenses, we need to get justice in this world. Another defense is a defense of insanity. It's provided in section 11 of the Penal Code Act. Insanity is a very good defense. They might be accusing you of a certain offense. Yeah, right, you did that offense, you carried out that crime. Let's take a case, they're accusing you of raping, defiling, stealing, murder. So this insanity can be raised as a defense in a way that you can inform, you can prove the court that by the time that action or that crime or that act was being carried out, you were not in your normal senses. So you have to prove the court. It's not a matter of saying that you were not in your normal senses and then you go. How to prove the court that really by the time I carried out that act, I wasn't in my normal senses. How to prove the court, how to go on and prove the court, bring the evidence that maybe you normally get attacked by certain diseases, or you normally off and on, and then you can easily be hard. But that is proved by either you bring the doctor's report, or you prove in any way that can easily favor you. So guys, you still have way out. You still have way to go away from those defense, from those criminals, from those criminal acts or those criminal charges, and you'll be safe. You'll be free in life. Another defense is the suicide pact. Suicide pact is provided in section 195 of the Penal Code Act. Suicide pact is when we believe like people have difficulties in life, people have challenges in life, and when people have challenges in life, they're normally forced to do different things, and then the most thing they normally point at is killing themselves. You know, some people, when somebody is, let's say, is passing through hard times, and that person feels like he or she wants to die. You know, somebody may be like, oh, before I die, let me do this. Before I die, I have to first kill this person, then I die. Because you're aiming at carrying out suicide, because you want to live life, a child of life, but you want to first finish up something, and then at the end of the day you don't commit suicide. You can, let's say you had killed a person, or you had carried out theft, or you had raped somebody, and then you didn't kill yourself. So remember, if you raped somebody, you still have those charges. And this defense of suicide pact, that you were forced by that feeling, that view, that belief that you're already going to die, so let you carry out this act, and it was just abnormal, like that's a normal happening. When you raise that defense, you can easily be hard. Your case can be easily hard, and maybe you can be charged of a lesser offense. You can be given either according to the defense, according to the evidence or proof that you brought on the table. So guys, it's good we know the defenses, it's good we know our rights, it's good to get justice. Everyone in this world needs justice. You and I, you and me still need justice. So my last defense will be intoxication. Intoxication is provided in section 12 of the Penal Code Act, from clause 1 to clause 5. Intoxication is whereby you carried out a certain act. Either, there are so many criminal acts like murder, rape, defilement, and so many others. But you carried out one of them, or you may have carried out two, but still you believe that no, I still need justice. I didn't do that in my own feelings, or when I was in my own ways. So you can also raise the defense of intoxication. Intoxication has to be involuntarily. If you had voluntarily used, intoxication, it also means that you weren't in your senses. You either use different drinks or drugs, and then your senses went off. But to raise this defense, you have it must be involuntarily. One must have caused that intoxication, not you. If it's you that had caused that intoxication, then my dear, you're not good to go. But if it's somebody else that brought out that intoxication, it was involuntary, you never wish to get intoxicated, and somebody carried out that thing, then you're good to go. You can easily raise it, you can easily be defended, you can easily go away from that criminal offense. So intoxication, it's majorly centered at involuntary intoxication. You should, to raise this defense, my dear, not this. You cannot raise this defense if you were self-intoxicated. If it's you that intoxicated yourself. Let's take an example. You had a feeling at a certain girl. You feel so good whenever she's moving. You feel so good whenever she's passing on, and you once told her, I love you, and then she neglected you, she ignored you, and then you be like, oh, I'll rape you one day. So you had that feeling, and then you be like, you cannot do it when you're sober, but you decide to take alcohol so that your mind can get ruled, changed, and then you easily carry out that act. So if your case was like that, then my dear, you cannot raise intoxication as a defense. But if let's say you had gone with a friend to take a drink, you were taking water, having to put in alcohol or other drugs in your drink, and then you get intoxicated, worry on your way, you raped somebody or you killed somebody, then my dear, you're innocent, but you just need defense. You can easily raise that defense of intoxication because it wasn't your will for you to do that act. So you need to be defended, you need justice, guys. I'm really happy to be with you here. I'm really happy to share with you what I had today. We shall be getting in touch always, we shall be talking always, and I wish you the best. Rebecca Cecilia, I love you so much. Keep tuned. Bye.